And Your Honor, again, for the record, my name is Ryan Robertson. I represent Mr. Anderson in this appeal. This appeal comes from a Department of Licensing decision suspending Mr. Anderson's license for 90 days for violating the implied consent law following an arrest for DUI. At the hearing level, and I don't believe any of the parties dispute this one fact, Mr. Anderson did not raise the issue whether or not the warning that was given to him by the officer was misleading and prejudicial. His attorney provided a different argument concerning whether Mr. Anderson was confused, not so much by the warning itself, but because he did not have reading glasses and did not recall getting the opportunity to read the warning himself. That issue is not before the court on appeal. On appeal is the issue whether or not the warning that was given to him, and that is an express finding made by the hearing officer in this case, that the warning that was provided to him was misleading and denied him the opportunity to make a knowing and intelligent decision to submit to the test or invoke his right to refuse. Now, the state brings this issue to the court's attention, and I certainly wish to respond to the issue about the matter not being raised, I apologize, for the first time on appeal. I think, and I argue, Your Honor, that the implied consent hearing process is a unique legal entity that separates itself from the general rule that issues may not be raised for the first time on appeal. There are a couple of distinctions that I believe have merit. One, the hearing process is a fact-finding venture by the hearing officer. We don't have opposing parties. We don't have a trial, civil or criminal. It's whether or not there's a sufficient amount of evidence before the hearing officer to make 4 required statutory determinations. Was there an arrest? Probable cause for the arrest? Did the individual receive warnings as required by statute? And then, did they submit to the test or did they refuse? A person does not have to speak. A person does not have to make a defense. A person does not have to say anything at all. In such a situation, the hearing officer has to look at the officer's sworn report and determine whether there is a sufficient amount of evidence for those 4 findings. The hearing officer has to make findings, both of fact and of law. And it is our argument that those 4 issues thus become embedded in the case and are available for appeal at a higher level. In essence, Your Honor, while the state argues that this matter is being brought to appeal for the first time, I characterize it, Your Honor, as these issues actually are not being presented for the first time on appeal. These issues are always available for review in any Department of Licensing case. Other things to consider, Your Honor, is that we are not alleging new facts. Certainly you can't bring new facts in on appeal. We're not addressing collateral issues. We're not suggesting performance of sobriety tests were not consensual or there was a pretextual traffic stop. We are not surprising anyone with a new issue that was not developed below. The hearing officer, whether Mr. Anderson said anything or not, had to make a finding if a warning was read, and had to make a finding that the warnings complied with statute, and that's required to meet the constitutional standard that a person be provided the opportunity to make a knowing and intelligent decision whether to submit to the test or refuse. Every case that comes from the Department of Licensing comes with it those findings and that conclusion. And, Your Honor, that is why we think there is a distinction in law between issues that are purely brought for the first time on appeal and those that are embedded in the case itself. Your Honor, I don't know if you had a chance to review my reply brief that I was able to file yesterday or 2 days ago. My bench copy was filed yesterday. A case that I found and I bring to the court's attention is, I believe it's called Osborne versus, I believe it's a hospital district in Grant County of all places. And this case is from the Supreme Court, and I believe it explains pretty accurately the issue that is before this court. And that is, when you, factually in the Osborne case, I wish I could find it at this point in time. In the Osborne case, a person claimed negligence. He was injured in a hospital. And he sued the hospital claiming negligence. The trial court at halftime dismissed the case, finding that he had not established that the hospital was at fault or its staff. Basically, a finding was made that the staff was complying with doctor's orders in the treatment of the patient. On appeal, the appellant raised the issue of a statutory duty of care for the hospital to care for patients under the care of the hospital. That argument was not presented to the trial court on appeal. Quite naturally, the respondents challenged that argument, stating that standard was not before the trial court and may not be raised for the first time on appeal. The Supreme Court held that the appellant could raise that issue. And again, wishing that I could desperately find that citation in my additional material.
At 206.
Thank you, Your Honor. The issue of the hospital's duty for safety of its patients was squarely before the trial court. The issue of the adequacy of the warning in any DOL hearing is squarely before the court, and therefore it is not an issue that is raised for the first time on appeal. Now, as it relates to the issue of the adequacy of the warning, Your Honor, the standards involved have to be very clearly stated. One, we're not advocating that there was a failure to provide additional information to Mr. Anderson. Certainly, it is an enticing argument to say that Mr. Anderson should have been told that because he was a commercial driver, he was subject to a one-year CDL disqualification whether he took the test or refused. But we know from State v. Bostrom that's not the standard. We cannot ask for warnings to be tailored to Mr. Anderson. In this case, and in a lot of cases, Your Honor, the state provides a generic form to all drivers, and that form has information on it that's not found in statute, 4620308, subsection 2. That's the bare minimum all drivers need to be told, whether they're a commercial driver or what have you. Mr. Anderson, if he were given just those warnings and nothing at all about the consequences to his CDL, would have no argument before this court. The state grafts information onto the warning, telling the individual that if he's driving a non-commercial vehicle, his CDL shall be disqualified. Essentially, if his personal license is suspended or revoked, his CDL shall be disqualified. And then there's a separate advisement for commercial drivers driving a commercial vehicle. It's not required by law. It's not required by statute. The question is, when the state grafts additional information onto the warning, it's not whether it's a correct statement or not. It's a question whether it provides a misleading interpretation. Now, there are examples where there were additional information to drivers and it was not held to be misleading. In Moffett and Clyde Hill, the information that was grafted onto the warning had no bearing, had no effect, no prejudice to anybody, and therefore no harm, no foul. And certainly there are cases where the information given to drivers was false, like Cooper versus Department of Licensing, a misstatement of how long they shall lose their license. That certainly was a misstatement of law and of fact and was prejudicial. But also, accurate information can be given to drivers, and it can be misleading. And the example of that, Your Honor, is Gonzalez versus Department of Licensing. Quite honestly, Your Honor, it has baffled me for years how the information given to drivers in Gonzalez affected the decision to take the test or to refuse. They were not misled about consequences to their license. They were only told that they would have to pay for their own blood test if they so chose. That is a correct statement of law. It's a correct statement of law for those who are not indigent, and it's technically correct for those who are indigent because they will have to pay for that test, and they can seek reimbursement from the state at a later time. Nonetheless, the Supreme Court held in Gonzalez that the inclusion of the at-your-own-expense language was a misleading statement. They didn't say it was misleading because they could pinpoint exactly why people refused a breath or blood test. They found it misleading because it could affect a person's decision to take or refuse the test. That's almost identical to the language that was in Cooper, where the court said that if it was possible that Mr. Cooper thought he would lose his license for a different period of time, he was prejudiced and misled. In this case, drivers are given the additional information that if their license is suspended or revoked, clearly defined by statute and clearly stated in the warning, if your license is suspended or revoked, your CDL shall be disqualified. That additional information creates a misleading response, a misleading interpretation. If your license is suspended, the warning tells you it shall be for at least 90 days. If your license is revoked for refusing the test, your license shall be revoked for at least 1 year or more. There is a natural built-in level of coercion. The state and the statute and the legislature wants people to submit to breath tests. So they tell them about the disparate treatment you'll receive You'll get your license back much faster if you take the test than if you refuse. The link and the problem with this warning, Your Honor, is that the added information provides no explanation to drivers to not differentiate that built-in level of coercion for your personal license with your commercial license. You're only told if your license is suspended or revoked, your CDL shall be disqualified. It doesn't say anything about for how long your CDL shall be disqualified. If a driver reads this warning, they are being misled to believe that if your license is suspended, i.e. for 90 days, that's how long your commercial endorsement shall be disqualified. But if your license is revoked, i.e. for 1 year, that's how long your CDL shall be disqualified. Because under statute, you can't have a CDL endorsement without a valid license. So it's natural to assume that the length of CDL disqualification is identical to the length of personal license suspension or revocation. In terms of prejudice, Your Honor, this isn't necessarily an issue about a commercial driver's license. This is about a person's ability to make a knowing and intelligent decision under the implied consent law. We have the right to take the test and we have the right to refuse. We can consider a decision to refuse not advisable. You'll lose your license for a longer period of time. Your refusal shall be used against you at trial. And there's other sentencing enhancements if you're convicted for DUI with a refusal. But it's a person's choice. It does, and I can state from practical experience, and maybe Your Honor knows this as well, it makes it a little more difficult for the state to prove a DUI without a breath or blood test result. So that's the person's choice. Mr. Anderson had the opportunity to invoke his right to refuse. He was told, and I believe was led to believe through the warning, that if his personal license was suspended or revoked, and if his license was in fact suspended for 90 days, his CDL disqualification would be for the same period of time. That is a misstatement of law. That is an inaccurate statement of law. And it is misleading because it falsely applies that built-in level of coercion for personal licenses to the CDL endorsement. And as we know, a CDL endorsement has a much closer link to a person's ability to drive and earn a living. For those reasons, Your Honor, we believe that the warning that Mr. Anderson was given, even though if you parse it out, had accurate statements of law, in its context was misleading and implied and conveyed a different meaning than is intended under our statutes. It was prejudicial because it denied him a meaningful opportunity to decide to refuse the test. One last thing, Your Honor, one of the points that is brought up by the state is the fact that Mr. Anderson didn't say anything about this when he testified before the hearing officer. And a couple of responses, Your Honor, are this. The credibility determinations were made by the hearing officer. The hearing officer chose really not to believe Mr. Anderson and to make factual determinations based upon the police report. And so the police report are the facts that were believed by the hearing officer. And those are the facts that are believed before the court. We're not asking this court to reconsider credibility determinations. And second, from the Gahagan case, these issues of a misleading warning are not issues of confusion, but misinformation. And if a person expresses confusion about an implied consent warning, it really doesn't matter what it was that may be wrong with the warning. It's the person expressing the fact that they don't understand something. The warning can be fully accurate. It can be the exact same language in the statute, but it confuses them. The issue then is, did the officer clarify that confusion? And that's where the cases usually fall on appeal. In these cases, it's not confusion, it's misinformation. And I think that the simple question is, how does a person ever know that they're misled? How would Mr. Anderson have known that he was receiving misinformation? How would any driver know that? They wouldn't. I think any person in any situation won't know till after the fact that they were given misinformation. Unfortunately, in this situation, with a lot riding on the line, Mr. Anderson made a decision to submit to the test and gave up his right to refuse on information that implied something in law that is not true. And for that reason, Your Honor, we believe that the hearing officer erred in making the findings, unchallenged as they may have been at the hearing level, but the findings that he was provided a knowing and intelligent opportunity, we believe is not supported by law. We'd ask for a reversal.